Hi friends. In this video, we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of Constitution, that too in relation to matters involving the right to establish an educational institution is a fundamental right under Article 19, 1G of the Constitution. To know more about the educational institution establishment case, please watch this video fully. If you feel that it's useful to you, please like, share, and comment, and never ever forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled Pharmacy Council of India vs. RAJEEV College of Pharmacy and others pronounced on 15 September 2022, the Supreme Court has held that the right to establish an educational institution is a fundamental right under Article 19, 1G of the Constitution of India, and reasonable restrictions on such a right can be imposed only by a law and not by an execution instruction. The facts of the case would be that by way of a resolution, Pharmacy Council of India resolved to impose a moratorium on the opening of new pharmacy colleges for running diploma as well as degree courses in pharmacy for a period of 5 years starting from academic year 2020 to 2021. Thereafter, the resolution was modified to the extent that, inter alia, the moratorium was relaxed for government institutions and institutions in the northeastern region and states or union territories wherein the number of institutions offering D. Pharm and B. Pharm courses, both combined, are less than 50. The writ petitions filed by the institutions before the 3 high courts challenged the validity of the said moratorium, and also prayed for a direction to be issued to the appellant to grant approval for opening new pharmacy institutions imparting pharmacy courses for the ensuing academic year of 2020 to 2023 on the basis of inspection conducted by the Pharmacy Council of India in February 2020, and to not insist on fresh applications from the institutions pursuant to the circular of the Pharmacy Council of India, which was issued in compliance of the interim order of this court dated 31st May 2022, and the same were allowed. Being aggrieved, the present appeals have been filed. The moot question, therefore, that requires consideration, is as to whether the moratorium, as imposed by the Central Council of the appellant, could have been imposed by the said resolution, which is in the nature of an executive instruction of the Central Council. The Supreme Court has held that the Constitution Bench of this court in TMA Pi Foundation vs. State of Karnataka, and others reported in 2002, 8 SCC 481 holds that in view of Article 19, 1G, and Article 26 of the Constitution, all citizens and religious denominations are conferred with the right to establish and maintain educational institutions. Also, the Constitution Bench of this court in PA Inamdar and others vs. State of Maharashtra and others reported in 2005, 6 SCC 537 again reiterated that the right to impart education is a fundamental right under Article 19, 1G of the Constitution and, therefore, subject to control by Clause 6 of Article 19. Such a right is subject to the laws imposing reasonable restrictions in the interest of the general public. The laws may be enacted for prescribing the professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business. The laws could also be enacted for the purposes of the carrying on by the state, or by a corporation owned or controlled by the state of any trade, business, industry or service, whether to the exclusion, complete or partial, of citizens or otherwise. Also, a citizen cannot be deprived of the said right except in accordance with law. The requirement of law for the purpose of Clause 6 of Article 19 of the Constitution can by no stretch of imagination be achieved by issuing a circular or a policy decision in terms of Article 162 of the Constitution or otherwise. Such a law must be one enacted by the legislature. The right to establish an educational institution is a fundamental right under Article 19, 1G of the Constitution, and reasonable restrictions on such a right can be imposed only by a law, and not by an execution instruction. Therefore, The view taken by the High Courts of Karnataka, Delhi and Chhattisgarh lays down the correct position of law. Since the resolutions or communications of the Central Council of the Appellant, which are in the nature of executive instructions, could not impose restrictions on the fundamental right to establish educational institutions under Article 19(1)(g) of the Constitution, this court does not find it necessary to consider the submissions advanced on other issues. Thus, the resolutions or communications of the Central Council of the Appellant are liable to be struck down on this short ground. Further, there could indeed be a necessity to impose certain restrictions so as to prevent mushrooming growth of pharmacy colleges. Such restrictions may be in the larger general public interest. However, if that has to be done, it has to be done strictly in accordance with law. If and when such restrictions are imposed by an authority competent to do so, the validity of the same can always be scrutinized on the touchstone of law. The applications seeking approval for D. Pharm and B. Pharm courses are required to be accompanied by a no objection certificate from the state government and consent of affiliation from the affiliating bodies. While scrutinizing such applications, the Council can always take into consideration various factors before deciding to allow or reject such applications. Merely because an institution has a right to establish an educational institution does not mean that such an application has to be allowed. In a particular area, if there are more than sufficient number of institutions already existing, the Central Council can always take into consideration as to whether it is necessary or not to increase the number of institutions in such an area. However, a blanket prohibition on the establishment of pharmacy colleges cannot be imposed by an executive resolution.